The Supreme Court yesterday smacked down Obamacare's contraceptive mandate. But is the White House already thinking of ways for the president to sidestep the decision with a pen and a phone?
As we have with a range of other things, we'll consider whether or not there's an opportunity for the president to take some other action that could mitigate this problem.
Really? Well, in the past 2 weeks, the Supreme Court has ruled against the administration a number of times in a number of high-profile cases. Is the High Court sending the administration a message about its limits of power? Let's talk to Fox News senior judicial analyst, Judge Andrew Napolitano. Judge, the White House has had a bad week.
It sure has, Steve. Yesterday, in particular, the president's signature piece of legislation, perhaps the most controversial part of it, was invalidated. Technically a rule issued by Mrs. Sebelius, Kathleen Sebelius, when she was the Secretary of Health and Human Services, is what was invalidated. The reason that came about as a rule is because Congress would never vote to require the American people to have health insurance that covers contraceptive services, among which is abortion. So because they couldn't get a majority vote in the Congress, they just issued this rule on their own, forgetting that issuing a rule like that violated another statute that Congress wrote 20 years ago, and that's what the Supreme Court smacked them down for yesterday.
See, a lot of people just don't get the historics of it, and that is the fact that this contraceptive mandate was an invention when they were running for re-election and the war on women.
Yes, because the president...
It was never passed by Congress.
Correct. Yet the president promised his base that it would become part of the law of the land. And as you said in your introduction, or intimated in your introduction to this segment, he loves so much to rule by pen and phone rather than by legislation enacted by Congress. This was a way he was able to rule by pen and phone. Call up Mrs. Sebelius and say, hey, write a rule requiring all these insurance policies to cover abortion.
Sure. And then there was a case that involved SEIU. Some women who take care of their disabled children out in Illinois were being compelled by the law of Illinois to join the SEIU. And yesterday the Supreme Court said, no, you don't have to join a union.
You know, actually, the defendant there was the governor of Illinois. But these are all the president's cronies from Illinois. Was 100% with them. A very selfless woman decides to stay home to care for her disabled child 24/7. She receives some income from Medicaid for doing it. The state says, we're paying you income. You're a state employee. You're a state employee. You join the state labor union. You're a member of the state labor union. You pay dues. Wait a minute. They don't negotiate for me. The federal government sets my wages. It's a paltry wage. It's a minor reimbursement for taking care of the child I brought into the world. I didn't want to have anything to do with the labor union. And the Supreme Court agreed with her.
Of course. You know, it is ironic that a guy who used to teach constitutional law doesn't understand how the Constitution works.
You know, yesterday, Josh Earnest, we just had him on the screen, the president's press secretary, referred to the president as that lawyer in the Oval Office. He's not even a lawyer anymore. He doesn't even have a license to practice law.
But that's the small print.
Yeah, for him it is, yes.
All right, Judge Napolitano, thank you very much.
Pleasure, Stephen.
All right.